ध्यान देना शुरू करोगे तो पहले बताओगे सबको कि हमारा ये ट्यूब ऑनलाइन हो रहा है, ठीक है? और मैं शुरू कर रहा हूँ तब, है ना?
कर दिया मैंने YouTube पे।
जब गायब हो जाओ तू।
सर आ गए नहीं अभी?
हो रहा है विकास।
एक मिनट।
हाँ हाँ
ऑनलाइन हुआ है सर, बंद हो गया तो हम
गुड इवनिंग सर।
कैसे हो?
सर नमस्कार।
कैसे अभिषेक?
बढ़िया सर, नमस्ते। स्टार्ट करें?
हाँ यस। हाय ऐश्वर्या।
गुड इवनिंग सर।
गुड इवनिंग, हाउ आर यू?
वेरी गुड सर, आप कैसे हैं?
हेलो एवरीवन। लेट मी ब्रिंग इट।
पहले बता दो लाइव चलेगा।
हाँ। Hello everyone. Today I welcome you all on behalf of Supreme Court Young Lawyers Forum. Today we are gathered here for a discussion on the topic elevations to judiciary, the trial and tribulation of advocates practicing before Supreme Court. As we know, we are an organization of Supreme Court advocates. But the ultimate difficulty we face when the time comes for elevation to higher judiciary, we are the people who are least considered for elevations because we don't practice in different high courts, and high courts consider only high court lawyers. So for discussion on this topic, we are in this webinar today. I welcome Mr. Vikas Singh, Senior Advocate and President Supreme Court Bar Association for this webinar. I also welcome our guest of honor, Ms. Aishwarya Bhati, Senior Advocate and ASG. Now to start with, I would like to request Mr. Vikas Bansal, the President of Supreme Court Young Lawyers Forum. Mr. Bansal, please start with.
Thanks Abhishek. A very warm welcome to everyone. Chief guest Mr. Vikas Singh, Senior Advocate and President Supreme Court Bar Association, a dynamic and bold leader of the association. Guest of honor Ms. Aishwarya Bhati, Senior Advocate and Additional Solicitor General of India, also the former Secretary, Supreme Court Bar Association. All viewers, my colleagues at the bar, ladies and gentlemen. First of all, I myself and on behalf of Forum, am very much grateful to both our distinguished guests for accepting our humble request and sparing their precious time for us. Today, we are assembled here on this platform to discuss the topic elevations to the judiciary, the trial and tribulation of advocates practicing before the apex court. Approximately 5,000 lawyers regularly practicing before the apex court do not get a chance to be elevated as a judge of the Honorable High Court, which is why the topic today has become a burning issue. Because of no regular practice in the respective High Court, we the advocates practicing in Supreme Court are not recognized by the judges of the High Court, and thus during the time of elevation, we do not stand a chance even after putting in a substantial amount of time and efforts. Therefore, some via media need to be developed so that the advocates regularly practicing in Supreme Court to get a chance to be recommended for elevation in their parental High Court. We hope that both our distinguished speakers will do the needful in our interest. Thank you. Namaskar.
Thank you very much, Mr. Bansal. Now, I would like to invite our chief guest of today, Ms. Aishwarya Bhati, Senior Advocate and Additional Solicitor General of India. Kindly say a few words.
Abhishek ji, chief guest is our president, sir.
Sorry, guest of honor.
But sure, you have invited me to speak first. I will share my thoughts and some views on that. Warm good evening to all of you. It's really wonderful to meet with your colleagues away from the virtual screens of the court. Of course, this remains a virtual screen, but it's really nice to see all the lovely faces and all the colors on the screen away from the black and white that we usually see each other on the screen. The topic that you have chosen for today's deliberations, Vikas ji is right in pointing that out, that it is an important issue. It is, I'm not too sure if I will say it is a burning issue, but it is an important issue and it needs consideration and deliberation. And I think we have, as president of the Supreme Court Bar Association, we have the right person to speak about it also. Some of the thoughts that I have is, I think, what we need to understand and appreciate is that as lawyers practicing in the Supreme Court, we anyway start at a very difficult slate. Supreme Court is not a place for young lawyers or a very comfortable place for young lawyers to start their practice at. If lawyers choose to practice in the Supreme Court, they anyways are extending the gestation period that is there for the lawyers. Law is not a profession that has an easy gestation period. Lawyers are equated with professions which take off very quickly. I mean, it is really the nature of the profession. So we are not in this, it's not an instant coffee, instant noodle kind of a thing. It is the simile that I like to give to some of my younger colleagues is that if somebody was to choose a field of sport, field of Bollywood, or modeling or athletics or any other area, or even a regular job. I mean, when you start early, 14, 15, if you're choosing sports, athletics, etc., your career starts when you're 14, 15 years of age. But your career stops by the time you are in your late 20s. You have to be a Sachin Tendulkar or an Amitabh Bachchan to really survive beyond your 50s and 60s in the profession. But unlike that, the legal profession is a profession where look at us. We are speaking on Young Lawyers Forum. We are all lawyers who have practiced. Of course, President Sir is the senior most. But even apart from that, all of the young lawyers here are lawyers who have put in 10 years, 15 years, 20 years plus of standing at the bar. So I think that is one thing that we need to bear in mind, that our profession is not like creating a instant noodle or quick dal chawal or even a quick roti sabji. I think when we choose this profession, we have to appreciate that we are trying to prepare chappan bhog, and this preparation of chappan bhog is going to take a long time. But of course, then you can savor it also for much longer. So even in your 50s and 60s, you continue to be young lawyers, and you come in the category of top lawyers of the country only once you have crossed 60 years of age and you are between 60 and 90. Of course, you have exceptions like Venugopal sir, Fali Nariman, Ramjit Malani, stalwarts of our bar. Now, the important time to be picked up for judgeship, it is really between 45 to 55 years of age, 45 being the minimum threshold, and 55 being a good age, between 45 and 55. But as lawyers who are practicing in Supreme Court, the gestation period becomes even higher, because when we are practicing in the highest court of the country, then here the struggles, the turbulations, being away from home, most of us practicing in Supreme Court have come to Delhi. This has, of course, become our second home, but we are not inherently from here. So the troubles and struggles of being away from home and trying to make a mark or make a standing of your own here, that also adds up. So it is not like the standard can in any way be, and of course, the most important part is if there are good lawyers who are in that age bracket, then it is always said, why don't you go to the High Court, go practice before the Chief Justice, let the Chief Justice see you, go to that High Court, go to Home High Court, so that there is some visibility. And then we have also seen that recent years, there have been some elevations that have happened from Supreme Court Bar Associations, and there was an element of resistance, or there was an element of almost bordering to the aspect of almost a negativity from the local bar. So that also is one important aspect that needs to be borne in mind, that the local bar thinks that Supreme Court lawyers are outsiders and they have aspirations and hopes of elevations from the local bar. So that bar feels insecure and intimidated if Supreme Court lawyers are paratroop from top and they have not really spent years in those high courts. I think these are all problems that we have seen, but increasingly there is more and more number of bright Supreme Court lawyers who are picked up for elevations. And I think the most important aspect is how their performance has been. The lawyers who have been picked up, there are some very competent advocates on record. They're very competent, and successively over the last 10 years or so, the presidents of the bar have raised this issue with the collegium, which has led to a large number of lawyers being picked up. It's still not as sufficient as it should be, because Supreme Court does have a place which has a lot of merit. Vikas ji mentioned that we are almost a collection of 5,000 regularly practicing lawyers in Supreme Court. And these are lawyers who are coming from across the country. They have their home high courts across the country. So if good meritorious candidates are picked up, and the vacancy positions across the country are abysmal, so those vacancy positions with good merit, if it can be filled up, then that is going to bolster the system even more and make our institutions better places. I also want to briefly mention about elevations directly to Supreme Court. That has also been an area of complete taboo for the first 60 years of our existence as a democratic republic. But we saw, starting from the time, of course, earlier, there were very few examples, Justice Kuldeep Singh, Justice Santosh Hegde. But the time of Justice Lodha was a very refreshing and remarkably different time, when we saw very strong candidates and respected lawyers from the bar were picked up for elevation directly to Supreme Court. We have seen many of them were our senior colleagues, and we saw their performance on the bench. And the bar is extremely proud of those lawyers who went on to adorn the bench and have imparted justice. So what is important for us to realize and see is that the performance of these meritorious lawyers, whether they have gone to high courts, whether they have been elevated to Delhi High Court, also saw some elevations, very far in between, very few in between, but some very strong advocates on record of the Supreme Court got elevated there. One has come to Supreme Court, is on the bench now, Justice Ravindran, Justice Muralidhar. These are names which have commanded respect everywhere. Ultimately, it all comes down to the kind of nomination that is made, the kind of candidate that is chosen. And I think as lawyers, it is important for all of us to ensure that we stay competitive, we stay meritorious, we enhance our knowledge so that we are in a position to contribute. And I also want to mention briefly, there is of course an application that is filed by the Women Lawyers Association, but the representation of women also needs to be mentioned here, in at least in passing, because that is also one area where more needs to be done. Of course, I agree with Justice Indu Malhotra when she said last month on her farewell that you can't have women lawyers paratrooping just for the purpose of being there as women lawyers and women judges. We need to have meritorious women lawyers filling up these spaces. But there are enough and more meritorious women lawyers. And I must also mention one comment of Justice RBG, the famous RBG, who we lost 2 months back, 3 months back, the second woman judge on the US Supreme Court. And when she was asked that, did you ever imagine that you would become a judge of the Supreme Court of United States? And she said, how can somebody aspire to be a judge or to be something that there has been only one example in history? So there was just one example before her in history of a woman becoming judge in the US Supreme Court. So we need to have more and more of these examples so that young girls and young law students and young law interns can work hard towards it and can aspire for those positions. Again, to quote RBG, US Supreme Court has 21 judges in all. So she was asked that how many women judges would be enough when do you think would it be enough number of women judges on the US Supreme Court? And she said 21. And the reporter who was asking that question said, well, 21, you want all to be women judges? So she said, well, it was all right when all 21 were men. So why are you raising your eyebrows when I'm saying all 21 should be women? So I think the focus point for all of us to appreciate, understand, and really emulate and focus on is that merit has to be there for our institution to have the right judges. The job of dispensation of justice is Yato Dharma Stato Jay, as the emblem of Supreme Court, and that dispensation of dharma, dispensation of justice is that is why it's a supreme godly. It's not really a job; it's a calling, it's an honor, and we need to have the right meritorious candidates adorning us on the benches. And I have no doubt in my mind that with strong leaders of the bar that we have, and with more and more meritorious lawyers that we have practicing in Supreme Court, merit from across the country. Today, our Supreme Court corridors have best of the lawyers from the entire length and breadth of our country. More and more of these meritorious lawyers are going to adorn the bench, and then more and more this will really snowball as a snowballing effect, because these lawyers are going to perform so well that they will become a commodity that everyone looks forward to, and they make us proud. Thank you very much, Vikas ji, for allowing me to share my thoughts and views here. Thank you.
Thank you very much, Aishwarya ji. And it's very nice to hear your views. And I would like to mention one more thing at this stage. Not only elevations, but when we try for this designation of seniorship, we see across country the rules prescribe that only the advocates enrolled with that bar council and practicing enrolled with that bar associations, particular bar associations of that state, they are entitled to get designation.
It should also be considered.
We can't even apply there in other high courts. A few high courts are there who can grant designation, but not all. And similarly, elevations we can't even think. So at this stage, I would like to invite our chief guest of today, Mr. Vikas Singh, one of the most dynamic Supreme Court lawyer and president of Supreme Court Bar Association. Vikas sir, please.
First of all, I must thank Vikas Bansal and Abhishek and the rest of the team for the Young Lawyers Forum to have thought of this subject and invited me to speak on this subject. It's a very, very important subject according to me. And this subject needs to be discussed more and more so that this acceptability of Supreme Court lawyers being elevated is, something which has to be accepted as the rule rather than the exception. And I would also like to say that Aishwarya Bhatti has also said some very nice words with regard to how things should happen in the days to come. And as the president of the bar, it will be my endeavor to see that in my last tenure as well. And I will try and ensure that there is some regular method of considering Supreme Court lawyers for the purpose of elevation to the various high courts. Now, this subject is a very, very interesting subject in many ways. You look at the manner in which elevation were being done prior to the Skora judgment, that is of 1998. The decision for elevation used to be taken at the level of the executive. And ultimately, the final say also used to be of the executive, and that is how the appointment process went on. It is only since 1998 that after the judgment of the Supreme Court, that nine judges, that they have decided that no, there should be a collegium system to make the recommendation, and that collegium system will ultimately go through the Supreme Court collegium, and whatever the Supreme Court collegium says with regard to appointment will be the final say. Now, a lot of criticism has been there about whether this judgment is correct or not, or whether this taking over this authority or power by the Supreme Court for making all the appointments to the higher judiciary is justified or not. And it is pursuant to that debate that the Judicial Academy constitutional amendment happened, which again was challenged in Supreme Court and upheld, and that was ultimately quashed. and the system as it was remained. I have actually written several articles on this subject, and interestingly, I have also drafted a bill in 2017 for appointment to the higher judiciary. And in fact, I've shared my bill with the government also, but unfortunately, they are not interested, because I said even if the NJSC may have failed, there can be a bill to regulate the collegium system. And to that extent, the parliament would be justified in making such a law. And if the law was to be made, then it will pass the judicial scrutiny, and it will pave the way for elevation of good people to the higher judiciary. Now, the whole purpose of this collegium system, bill to regulate collegium system, which came to my mind was, and which I would like to share with our viewers today, that when you talk of assuming the power to appoint judges, there is a huge amount of responsibility attached to that power. And that responsibility is to look at the right names, and to ensure that the best of the best. I know of several instances of this court, Supreme Court, where we have lost people from being elevated to the judiciary because nobody asked them to be elevated. It's the point that I the point that I'm wanting to emphasize is that the good lawyers, or rather lawyers with a decent practice, actually start earning money. As Aishwarya Bhatti mentioned, it is not a 2-minute doodle. It's a long drawn process of getting into the profession and start earning money. So you start earning money in your 40s, 50s only. That is the time when you really are at the takeoff stage. That is the age at which somebody should offer you to become a judge. If you are not offered to become a judge, then probably you're not interested, because that's the time you're really earning money. So the responsibility of the collegium is to identify the right people and request them and ensure that they are elevated. Now, the question every time asked is that how does the High Court Collegium know a particular lawyer practicing in the Supreme Court? And my answer to that is that when you even look at elevation within the High Court and the High Court Collegium considering names for elevation, the Chief Justice of India may be only looking at, say, public interest litigation, or maybe constitutional issues, or some Chief Justices are good in tax, like Justice Kapadia, so they like to hear only tax matters. Lawyers being considered for elevation may not appear before them also, for some other benches in the same High Court. Lawyers within the state, forget Supreme Court, within the state may not be practicing in the High Court at all, practicing in the lower courts, but they may be very good in their branches and very eligible. For instance, a tax lawyer may be appearing only in the ITAT, may not be coming to the High Court very often. Or even if he comes to the High Court, he may be going before a particular bench which may not be part of the collegium. And similarly, like criminal matters, there are a lot of criminal lawyers who could be practicing in the original side, in the trials court side, and coming very rarely to the High Court. And in the High Court, they may be appearing before judges who are not part of the collegium. So the plea that you take, that a Chief Justice or the members of the collegium should have seen you and assessed you to decide whether you should be elevated is, according to me, completely fallacious, because that begs around the theory that the lawyers who are being considered for elevation should be appearing before the chief court or the number 2 or the number 3 court. I mean, those are the only 3 court people who are appearing in only these 3 courts are required to be elevated. According to me, a proposition which has no legs to stand on, and every time a plea is taken that because that person is not practicing in the High Court should not be considered for elevation is completely, according to me, without any reason. when you decide to take power of appointing judges, then it is your duty to locate the right people wherever they are. Law firms, they could be in Supreme Court, they could be in trial courts. So if wherever you find that the eligible group is available, and when I say eligible group, you have to have for every high court, you have to have a certain amount of criteria. So for instance, income criteria could be different for different high courts. We will have a higher income category. Delhi also may have a higher income. A small high court like Jharkhand or Patna may not have that same income, minimum income requirement for being considered for elevation. So every high court, once it has a minimum criteria, as Aishwarya mentioned, the normal age is between 45. Actually, 45 is the minimum. And I would say 45 to 50 is the right age by which you should be considered. Only in rare cases, if somebody still wants to become a judge after 50 also, then maximum it can go to 55. So 45 to 55 would be the outer limit in which a person should be considered. Now, with the advent of technology, it is easily possible to have a database of lawyers from a particular state and practicing in any court and having the criteria of, say, between the age group of 45 to 55 being the one criteria. A particular income group could be the second criteria. Number of reported judgments, minimum number of reported judgments could be a third criteria. And on that basis, you shortlist all the names available, wherever practicing. And after you have those names available, then you consider each one of them to find out which amongst those names are the best. And it will be possible, or it would be several times you will find that some of the people who you consider are the best may not be interested in becoming judges. And that is the other responsibility which the collegium should take, of trying to convince them of becoming judges, that they need to serve the system as well, and they should be told. For instance, I was once told by Justice Dalbir Bhandari, Justice of the Bombay High Court. He had identified some 11 lawyers whom he said were judges. And when he requested them, out of the 11, refused straight away that we are not interested in becoming judges. So Justice Dalbir Bhandari told me that he then fixed up appointment with each one of those 9. Your home, I want to meet your father, your mother, and your wife, and you all together. And I want to discuss something with you. And then he says, I went to their homes, I talked to the parents, I talked to the wife, and I said that if you think that earning money is only your calling in life, you should be justified in rejecting this kind of an offer. Otherwise, if I'm offering you judgeship at a young age, at a good age, you have a chance to serve the judiciary for a long period of time. And he says, out of the 9, 5 he could convert. Now, that's the kind of effort we require to get proper elevation to the judiciary. And if you do that effort, because ultimately the quality of judgment, the quality of, I would say, democracy, is dependent on the quality of judges. And if we don't have good judges in the system, ultimately the democratic polity is at stake, and we can't have a robust and a healthy democracy without good judges being appointed. So similarly, I personally feel that as far as the Supreme Court Bar Association is concerned, there should be a system where the SCBA should recommend names. And here I will say that you need not go back to the same High Court from which you are, from the state where you are belonging. You could be given a choice to select your High Court. I know of cases where a Supreme Court lawyer has actually landed up in a High Court from which he does not belong. I would not like to name them here, but I have several instances in my mind where lawyers have gone and served as judges in high courts where they have no connection with, because they felt that they want to go to that particular court, and that option should, according to me, given. The Supreme Court Bar Association should have the right to simply nominate the names of judges, of lawyers practicing in Supreme Court to the High Court to which they are to be considered for appointment. and let the collegium consider their names in a transparent manner by comparing the merits of the candidates locally available vis-a-vis the lawyers of the Supreme Court who want to go there. And if they find them to be better than the local lawyers, it is only then and then that they should be considered for elevation. I don't want that the Supreme Court lawyers should have some kind of a quota to be appointed to the High Court. I'm saying that the effort should be to find the best in that particular age group and in that particular category which I just mentioned about that income, etc., and reported judgments. And amongst those, whoever is found to be the best are the ones who are eligible to be elevated. And that effort should not be at all determined by the knowledge of the three members of the collegium at the High Court or their personal knowledge of the three members of the collegium at the High Court. That knowledge should be based on some criteria which can be easily specified. Now, one thing which I suggested in that bill which I had drafted in 2000, it's called Facilitation of Appointment of Judges Act 2017. Now, one thing which I had suggested in that bill was, at the moment the names come, you collate all the names which come from whichever source, whoever fulfill that criteria, maybe a large number, maybe 100 vacancies, maybe only 5. And then you send them to a committee of 2 or 3 eminent senior advocates of that High Court. Analyze all the data. Why this is important? Because the moment you become a judge or in the collegium, by the time you get into the collegium, you are sufficiently distant away from the time you were practicing as a lawyer. And unfortunately, there is a huge barrier between the judges who remain judges for a long period of time vis-a-vis the judicial family, the advocates fraternity. So you lose that touch. But if anybody, if you want to find out about a lawyer being considered for elevation and you want to find out about his integrity, about his legal knowledge, definitely the lawyers in the profession, you are permanently practicing there, eminent lawyers of any court will be able to tell amongst the names being suggested as to who are the fit candidates and who are the unfit candidates, and their comments can be called for. All this information can be then placed before the collegium, and the collegium then ultimate decision will remain of the High Court collegium itself. This broadening or this selection of names consideration should be done with a very, very open mind, with a very, very open policy. You should not in any manner restrict people from being considered as being elevated. But after the names have come in the basket, to find out amongst those who are the best, you have several methods. And one of the methods which I am suggesting is to have the comments of 2 eminent senior, and those eminent senior advocates also will be decided by the collegium only. So it's not as if the government or anybody else will have any say in the comments that you are getting on all the names. Once you have all the names with you, with the comments, then you pick up the best names and recommend them for elevation. That, really speaking, will be the only way you can ensure that the best of the people are elected. And in that process, I am confident, because the kind of litigation that Supreme Court lawyers are, doing on a daily basis, because by and large, for a Supreme Court lawyer, you have to be a generalist. You can't even decide your specialization. I hardly know, I can hardly count, very few lawyers in the Supreme Court who would be doing only a particular branch of law. Every lawyer in Supreme Court is doing almost everything. Some broad classification of some lawyers doing more of civil and some lawyers doing primarily criminal. But that's the only classification that you can think of in Supreme Court. So the kind of work that a Supreme Court lawyer ends up doing is broad-based and is so, full of quality. His elevation to the High Court will always be an asset to the High Court institution, which is the judiciary at the state level. The names that have all gone from here are all of them have done exceptionally well as judges of the High Court. And the names that I remember from the beginning, Justice B.P. Singh was a lawyer practicing in Supreme Court. He went to the Patna High Court, then Bangalore High Court, Karnataka High Court, elevated, became a Chief Justice, came to Supreme Court. Gyan Sudha Mishra ji, again practicing here. Badr Ahmad, practicing here, went on to become Chief Justice of Jammu and Kashmir. Subramaniam Prasad recently has been elevated. Muralidhar presently is the Chief Justice of the Orissa High Court. All Justice Khanvilkar was practicing here in Supreme Court. So, I mean, if you pick up the names that have all gone from here, you will find them that all of them are exceptional judges. Done this institution proud. So, the more you select from the Supreme Court, the more you will do good for the higher judiciary and for the institution. And they are the ones who will most likely come to the Supreme Court as well. So this is some topic which even in my address in my last term when I was president in 17-18, and we had this Law Day function at the Vigyan Bhavan. And in my speech, I had taken this up when the President of India was also there. That there should be a proper system elevating Supreme Court lawyers rather than doing it on a pick and choose basis. What is happening today? Elevation is happening, but some judge of the Supreme Court has to push that particular name, and it is only then that elevation happens. That also, according to me, is not correct. Because anybody who is canvassing for his candidature to become a judge, according to me, that should be a disqualification. And once if you are good and if you fulfill the criteria, your consent should be taken. If you are not interested, then the same policy as Justice Dalveer Bhandari did should be adopted. If you are still not interested, probably then you may not get elevated. But the effort should be made to pick up the best. And in picking up the best, the names of Supreme Court lawyers should be considered as a matter of right, rather than as a case-to-case basis or as an exception. Recently, when this Orissa High Court matters came up for consideration before Justice Sanjay Kaul, and I was representing one of the parties, and then Sanjay Justice Kaul asked me to assist the court in the matter, and that is how I'm still appearing in that matter. Justice Kaul, when he was presiding, has actually recorded my submission in one of the judicial orders that Supreme Court lawyers should be considered as a matter of right, and they are not being considered, which is a matter of concern. And recently, when Justice Kaul was sitting with the Chief Justice, I think 1 or 2 weeks back, and when I again raised this issue that lawyers from the Supreme Court should be considered for elevation as a matter of right and not as an exception, and there should be some method by which lawyers practicing in Supreme Court should be, the names should be sent for every High Court and should be picked up if they are better than the local names. The Chief Justice agreed with me, and he said that whether he will make it a judicial order or whether he will do it administratively is a point which he will consider. But he definitely agreed with me in open court, and it was reported by the various bar and bench and other several newspapers also, that he definitely agreed with me that Supreme Court lawyers need to be elevated to the various high courts as a matter of right rather than as an exception. The last hearing which happened 2-3 days back, there was an application filed by lady lawyers practicing in this court that they should also be considered for elevation. And Sneha Kalita had sent me this application, and she had said that I should also assist the applicants in getting that issue raised or flagged before the bench. And unfortunately, this 302, which was with regard to elevation of filling up of the vacancies of the High Court, was not being taken up. But still, I mentioned that application to the Chief Justice, and I said that the government should come prepared on the next date of hearing as to what they intend to do with regard to elevation of lady lawyers practicing in this court. I personally feel that there is a huge disparity in appointment of women or ladies to the higher judiciary. And the percentage of women so far elevated is very, very small. This should be a issue of huge concern every collegium, and they should try and pick up as many women as possible to ensure that this gender gap is sort of, and we have more and more women practicing everywhere, and including the Supreme Court. So I don't want to when I say that a Supreme Court lawyer should be considered for elevation, I never say that they should be considered for elevation robbing the rights of somebody more meritorious in the High Court. I always say that the Supreme Court lawyer should be considered for elevation, whether it be men or women, on equal footing by comparing the names available in the High Court itself, and by having the rational basis of finding out which amongst all the names are the best names. And I'm confident that if this objective analysis is done, the lawyers from the Supreme Court who are being considered for elevation will always get selected as compared to the lawyers from the High Court, because of the quality of work being done in the Supreme Court, because the wide variety of work being done by the Supreme Court lawyers. In fact, I have met a large number of members of the collegium from various high courts in the recent past, in my earlier tenure as well as in this tenure. And some of them very frankly mentioned to me that you should insist that your name should also be considered by the collegium of the High Court, because they say that we don't have names in our High Court which we can think of being considered for elevation. This is especially true for smaller High Courts, where the quality of lawyers practicing is not so great, and they are actually having a problem of finding suitable names. So today the situation in the entire country is very alarming. We have about in a total 1,100 judges strength of the entire country, of all the high courts. We have more than 400 vacancies of judges. And as you all know, in every high court, the vacancies are filled up by 2/3, 1/3 basis. So 2/3 comes to the lawyers, and 1/3 goes to the higher judiciary of the state. So, as far as the higher judiciary is concerned, that is one thing which is determined on the basis of, mostly on the basis of seniority. That issue, really speaking, is not there. But as far as higher judiciary also is concerned, the same will apply when you appoint additional district judges to states. So you will see that in the recent past, a lot of our lawyers have gone as additional district judges in various states. If our practicing lawyers can go as additional district judges without any problem, by virtue of their merit, by virtue of the fact that they have done good work in the Supreme Court and have 7 years of practice in Supreme Court, I don't see why, by the same yardstick, lawyers practicing in Supreme Court can't be considered straight away for the High Court as well. So ultimately, whether it be through the higher judiciary, where again our people are being considered and should be considered, and we invariably our lawyers fare even for the ADJ appointments names. If the similarly, if the names for the High Court were to be considered, and an impartial analysis were to be done of the names that are available for elevation, then our people will definitely get elevated in large numbers. And lastly, I would like to end by saying that yesterday there was a discussion in the Supreme Court of appointing ad hoc judges. The whole idea of ad hoc judges was coming because there is a huge pendency in high courts. And because of the pendency, it is not possible for the existing strengths to cope with the pendency and appoint ad hoc judges. And the concept of ad hoc judges is that judges who have retired from the High Court are asked to serve again as the junior most judge of the High Court to dispose of matters. I am very firm of the view that no Chief Justice of the High Court should have a right to suggest names of ad hoc judges unless he has recommended names for all the vacancies, both in the promoting category as well as in the direct category. So, for instance, if a Chief Justice of a High Court has sent names for all the vacancies and the future vacancies in the next 6 months, and if those elevations are being delayed for one reason or the other, and then if he feels that there is a pendency issue which needs to be tackled because of that delay, he have the right to recommend some ad hoc judges. But otherwise, there should never be a system where appoint ad hoc judges without recommending for filling up the permanent vacancy. So that is something. It should not be a system where you bring in retired people to do the judicial work and continue the vacancies of the high courts without sending any name for elevation. I'm also very firm of the view that whichever collegium is to recommend names for the High Court of whichever High Court, they should send all the vacancies at one go. There should be no pick and choose. So what is happening is that 30 vacancies, they are sending 10 names. And after those names get appointed, then after 2 months, they send another 10 names and 15 names, etc. And do this in piecemeal. Now that results in a lot of heart burning. At times, the more senior person gets recommended in the second lot, and he becomes a junior judge to the names which were sent earlier. Something which is completely to be avoided, according to me. All names, all vacancies in the High Court should be recommended at one go. And it is only once the entire recommendations have gone and when they are pending for consideration, because this process also unfortunately takes a very long time. And the time which the government is taking is completely unjustified. So there should be some memorandum of procedure where the time limit should be absolutely spelled out, that this is the time limit in which a name which is emanating from the collegium of the High Court should be either rejected or accepted in a time frame, so that the elevation, because what happens is they give his consent at a particular age, and if his name doesn't go through for 2 years, he may not be interested after 2 years to be elevated. So that is something which should be completely avoided, and we should have a system where elevation, the collegium should have a time frame. So when we ask the government to have a time frame, also simultaneously ask the government, the collegium to have a time frame, and the collegium should not. I don't see any reason why a Chief Justice should take 3 months to familiarize himself with the High Court to send names. I mean, the day he takes oath, it should be his responsibility to spare time and find out the best names for the appointment. Recently, if you will all recall, that the question of having a full-time CBI director was being adjudicated in this. And the Supreme Court said that why should there be an ad hoc or a person officiating as a director? I feel that a judge's vacancy is far more important than the vacancy for CBI director. And there should not be any vacancy of a judge, sanctioned strength of a judge of a High Court, even for a day. So if there is unless there is a vacancy caused by death, you know when the vacancy is going to be arising, you know the date of retirement of a particular judge. We start the process of filling up that vacancy 6 months in advance, so that even before the judge retires, the name should be notified to take over as the judge in place of the retiring judge, like we have for the Chief Justice of India. When the Chief Justice retires, we have a Chief Justice designate notified earlier. So the day he retires, simultaneously the Chief Justice takes over. So similarly for a judge also, I feel that this process should be started so that this process is finished even before the retirement takes place, and there should never be any vacancy in any high court of a judge. And in the process, of course, the transparent method of appointment should take place, which will consider the best names. And I'm sure that the Supreme Court lawyers be amongst the best of the best be considered for elevation in the High Court. Thank you.
Thank you, sir. Thank you very much. Just one suggestion I would like to add in your. Sir, as you said, that the Supreme Court should select and should recommend names. Now, you being president of Supreme Court Bar Association, you should start, it's my suggestion only, you should start a drive to make a database and to provide it to Chief Justice of India as well as other high courts. You see, these are our lawyers whom we consider are eligible to be appointed. And if you consider them by comparing with their own advocates, you can consider them also. So you should start it.
No, that is definitely in my mind, and this I will do. I don't want to start sending names, without the Chief Justice of India being receptive to it. So I'm in that dialogue, and I'm sure within this tenure, I will be in a position to start this process of SCBA, EC suggesting names for various high courts. And once the names are suggested, the High Court will consider them on transparent basis, comparing them with the local candidates. And only if they find them to be suitable, they should be considered for appointment.
Thank you, sir. Thank you very much. I would like to invite Mr. Vikas Bansal want to say something.
Sir, similar thing I want to say that as a president of the Supreme Court Bar Association, to take initiative and prepare a mechanism. Criteria should be the person should be member of the SCBA at least for 20 years. He should at least 20 cases per year for last 3 years. And you suggest the name, and there should be some committee of judges of 7 judges different from the collegium who are here for at least 2-3 years. Suppose they are the maximum judge should be retired on 2023. So there should be some 7 judge committees only for this purpose, other than the collegium. And SCBA should take the initiative, and SCBA should send the name, and after this scrutinize, the SCBA should have the vital role on this. Otherwise, it would not be possible.
Try and evolve some mechanism whereby.
And we know as a president, Mr. Vikas Singh can do it. We know it.
Really.
Thank you for those kind words, Vikas. I will definitely try.
We know that.
Show you that.
Thank you.
And I'm quite hopeful that in this tenure, I should be able to do something.
Thank you.
Thank you, sir. Now, for vote of thanks, I would like to invite the Vice President of Supreme Court Young Lawyers Forum, Mr. Vikas Uday Gupta. Mr. Uday Gupta, please.
Thank you, Dr. Atre. I'm sorry, my sincere apologies. I joined a little late, but I followed my learned and very graceful colleague, Ms. Aishwarya Bhatti's speech on YouTube. There was some video problem at my end. And thereafter, of course, I heard the President SCBA's full speech here. And I think by now, both the speakers would have realized the manner in which our President and our Secretary vociferously wants a data bank of lawyers' name to be provided to the honorable judges, that this topic was chosen because it's close to everyone's heart, especially I think the first generation lawyers who perhaps don't have anyone backing them from behind as a lawyer in their family or as a judge, retired or sitting, whoever, easier way in the profession compared to the first generation lawyers. So on behalf of the forum, I would like to thank the President SCBA, Mr. Vikas Singh, and Ms. Aishwarya Bhatti, Senior Advocate and Learned ASG, for joining us today and sharing their views. I think everyone has got greatly enlightened, and a lot of issues have been clarified by both the speakers. And rest, I think there will be definitely some suggestions which the members of the bar can obviously offer to Mr. Vikas Singh and the entire EC, and he can take it up with the honorable judges of the collegium. On that note, normally I would have invited everyone for a cup of tea, but I think in COVID times, everyone would have to
We
share
have
a
our
cup.
own cup of tea here.
Of course. Yes, I was going to say that, so that everyone should now have a cup of tea. And it was really enjoyable to hear both of you. So very grateful to both of you.
Thank you. Thank you.
Thank
And
you.
Aishwarya, of course, I want to say special thanks because I have known her from '97 when she walked in from NLU Jodhpur, representing NLU Jodhpur, and I was organizing the All India '97, '98.
It was not NLU. There was no NLU Jodhpur then.
Okay, whatever that
It was the
Jodhpur,
old-fashioned
all
faculty.
Jodhpur, yeah, your Jodhpur faculty, and so that All India moot court, is not nostalgic, and from that time till today, we are very good friends. So very grateful to you also, Aishwarya.
Thank you so very much. It was
Thank
a
you
privilege
very
for
much,
me
sir.
to be here.
Thank you.
Thank you.
Thank you very much.
हाँ जी, अभी हैं तो अरे